Okay, so the Treaty of Waitangi is the hot topic at the moment. It's been all over the news and all over social media. There's been questions asked in Parliament. Green MP Chloe Swarbrick asked Prime Minister Christopher Luxon whether he believed that Maori ceded sovereignty to the British Crown. Christopher Luxon duly confirmed that he thought that they did. And then outside Parliament, of course, dear old Chippy, the leader of the opposition Labour Party, Chris Hipkins, he is of the opinion that Maori didn't cede sovereignty, but that doesn't mean, according to him, that the Crown doesn't have sovereignty now. So I'm listening to all of this and I'm looking at the decisions and things of the Waitangi Tribunal and thinking this is just extraordinarily misconceived right from the outset. So I thought that I would do a few videos on the Treaty of Waitangi because I am a preeminent professor on the subject. I just know everything about it. I read this book about it once. And I know quite a bit about British history and British legal history and constitutional law and stuff like that. So I want to shed my perspective on the Treaty of Waitangi, which is really, I guess, the British Crown perspective. So this is distinct. Usually you hear about things from the New Zealand side, from the New Zealand Crown side of things, or you hear about the argument coming from the Maori side of things. And I want to cast this as an entirely different light. I want to try and look at this from the British Crown perspective. Okay, so the first thing I think that we need to clarify is that the Treaty of Waitangi is not a race-based treaty. And what I mean by that is the fundamental mistake everybody makes, and it's insufferable really. And that is that they say that the treaty is between Maori and the Crown. It's not. Okay, and it's very important to recognise that it's not, because Maori is an ethnicity. And even though there's a correlation between the chiefs who signed the treaty all having a shared common ethnicity, that is not the party to the treaty. If you look at the treaty itself, it says quite clearly it's between the indigenous natives and the British Crown. Now that term indigenous natives has a specific meaning, and it's easy to understand if you take, by analogy, the example of a real estate contract. If you were reading a real estate contract and you saw the word vendor, you would know that that person they're represented in that contract as being the seller of the property. And so their authority for that contract is derived from their proprietorship on the property, not from their ethnicity. It doesn't matter what ethnicity the vendor is, you don't even know. But you can tell what their role is in the contract by that term vendor. And the term indigenous native has a specific kind of flavour and meaning in the same sense. You can tell what the British thought the role of the other party to the treaty was by the fact that they've called that party the indigenous natives. So the chiefs, it's not that hard to understand. The contest about sovereignty, we have to consider the fundamentals of sovereignty. The fundamentals of sovereignty are effective government over a territory and a population, so a defined territory and a population within that territory, and effective government over that is the kind of minimum sort of standard for sovereignty, if you want to put it like that, or that's the kind of sovereignty that the British Crown holds. So if you take that and you say to yourself, I'm going to cede that sovereignty, then because sovereignty results in things like nationalities, it's the right to rule. So when you cede that sovereignty, your power is derived from the right to rule, to give up the right to rule. It's not derived from the fact that you might be a particular ethnicity. And the same applies with the Maori chiefs. Their power to sign the treaty, their power to deal with the British Crown was derived from their nativity not their ethnicity. That's an incredibly important point, because it is the nativity, the fact that they are Indigenous natives, that tells a story about their status in international law, their status on the land, on the territory that they were in, according to the British, and the status and extent and quality and nature of sovereignty that they may have. So it's very important to keep the treaty parties very much identified clearly like that, especially the Indigenous native side of things. And the really good thing about being able to consider the treaty to be between the natives, Indigenous native people, and the British Crown is that it immediately takes race out of it. So it's no longer a race-based treaty, and any issues regarding the honouring of the treaty or dishonouring the treaty, depending on your point of view, those are not racially charged issues. They are issues that arise as a result of the nativity of the people. So there's a correlation between them holding a common ethnicity, these people, but it's the fact that they are natives from which their native rights are derived. And this is where you get the whole idea of sovereignty and native rights as it applies to natives. This concept of Maori rights is wrong. There's no such thing as Maori rights or Anglo-Saxon rights or Asian rights. What there is rights that are derived from what I believe Maori people in the Maori language call tangata whenua, or the original inhabitants of the land. And that literally equates to the same thing in Britain as an Indigenous native. So how this works is there's two types of land in the world. They can be broken down into two categories. There's land which has a sovereign power over it. So that's territory that belongs to a sovereign nation of some sort. And then there's territory that's unclaimed and undiscovered, or terra nullius as it's known. So this is land that no one has asserted sovereignty over. And that's the difference, because the people in the land where the sovereignty is asserted, in the British context, have a nationality. So they're not called Anglo-Saxons, they're called British. Whereas people who don't have a nationality, because they are not in a sovereign nation per se, are natives. And in the British way of looking at things, they were treated as flora and fauna. They were part of the land. So the British and international law observes that these Indigenous natives have rights, but their rights are nativity rights, not ethnicity rights. And if you consider them like that, that gives you a lot better starting point to consider what those rights might be, because those native rights are a subset of the nature and quality of the sovereignty that those natives might have held. So you have to look at it in a very nuanced way, and to do that you have to stick very rigidly to the facts. You can't deviate around and suddenly make this about an ethnicity, because if you do that, it just becomes a racial argument and no one's going to get anything out of it, because it's completely misconceived. If you make it a racial argument, you're fundamentally coming down to the single question of what justification is there for treating a person differently based on their ethnicity, and that's not an argument that can be made, because it's racism. Whereas if you actually get the proper argument, what you're coming down to is there a justification for a person being treated differently because they are the Indigenous natives of this land and we took them over, we colonised. I can't get my head around that word. Colonised. We colonised the land that the natives were on. So that's how the British perspective starts off. And of course, that flows onto the question of sovereignty, because sovereignty isn't a fixed thing. Sovereignty can vary. It depends on who's got it and how it all kind of unfolds. And that's a subject that I'm going to look at in my next video, which I should be putting out very shortly. Thanks for watching this one, and I hope we've got the starting point now where we've got it clearly fixed who the parties to the Treaty of Waitangi are. Thanks for watching.